Hello, it is now 1 p.m. Eastern Time. You have joined the Prosecutor-Led Diversion Program, engaging approaches to support individuals with mental behavioral health issues involved in the criminal legal system. To allow for additional signees past the hour, we will start the webinar in a few minutes. Good afternoon. I'm Demetrius Thomas, Deputy Program Director at the Council of State Governments CSG Justice Center. Thank you for joining today's Prosecutor-Led Diversion Program, engaging approaches to support individuals with mental behavioral health issues involved in the criminal legal system webinar. Today's webinar is funded by the U.S. Department of Justice, Bureau of Justice Assistance, BJA, and done in collaboration with the Association of Prosecuting Attorneys, APA. To give you an overview of today's webinar, first I will introduce the speakers, then there will be a brief overview on the Council of State Government CSG Justice Center and the Bureau of Justice Assistance, BJA. After that, there will be a brief overview on the APA. We will then go into our presentation, which will include some background and information on prosecutor-led diversion programs, a panelist Q&A, and then finally there will be a larger Q&A where you can ask follow-up questions to the panelists and speakers, which will then be followed by a quick closeout. Anytime during the webinar, you can ask a question by typing it into the Q&A panel on the bottom right-hand portion of your screen. This includes both technical and content-related questions. We will try to reply to technical questions in the chat window as we go. For the content-related questions, we will keep a running list and address them at the appropriate Q&A discussion in the webinar. We will do our best to get through as many questions as possible. If you encounter any technical or audio problems during this webinar, please call WebEx technical support at 1-866-229-3239. Please understand that there are some technical questions that may not be able to be resolved. However, we are recording the webinar and will post it on our website by the end of the week. Introductions. David Laban is President and Chief Executive Officer of the Association of Prosecuting Attorneys, APA. Prior to forming APA, Mr. Laban was the director of the American Prosecutor Research Institute, APRI, and the director in research and development for the National District Attorneys Association, NDAA. In this dual capacity, he directed APRI's projects, including editing and teaching in the areas of child and adult sexual assault and gang violence. Before joining NDAA, Mr. Laban was the executive director of the California District Attorneys Association, CDAA. He was involved in creating CDAA's first Violence Against Women project, the Circuit Environmental Prosecution Project, and the High Technology Prosecution Project. Mr. Laban is also a former deputy district attorney in Orange and Humboldt counties in California, where he received numerous awards, including being recognized for his community service work with victims and in the reduction of gang violence in the city of Westminster, California. Rebecca Neville is a staff attorney and member of the general counsel team at the APA. Prior to joining the APA, Rebecca worked in family law and served as an assistant state's attorney in Prince George's County, Maryland. She prosecuted general misdemeanor crimes and specialized in domestic and family violence cases involving spouses, families, and intimate partners. Rebecca obtained her JD and her master's in social work from the Catholic University of America and worked in the social services field prior to attending law school. Thank you both, David and Rebecca, for being part of this webinar. I am Demetrius Thomas, the Deputy Program Director in the Behavioral Health Division of the Council of States Government's Justice Center. I oversee the Justice and Mental Health Collaboration Program Training and Technical Assistance grantees. Prior to joining the Justice Center, I worked at the New York City Department of Health and Mental Hygiene, where I led the agency's work at the intersection of criminal justice and mental and behavioral health, including establishing the city's first ever diversion centers, co-response team, and mobile crisis teams. Next, I will provide overviews on the missions of the CSG Justice Center and BJA. The Council of State Government's Justice Center. The Justice Center is a national nonprofit, nonpartisan organization that combines the power of a membership association representing state officials in all three branches of government, with the expertise of a policy and research team focused on assisting others to attain measurable results. Our staff develops research-driven strategies to increase public safety and strengthen communities. This slide describes a bit about our work style and how we strive to reflect Justice Center core values, which includes a commitment to being independent and nonpartisan in every aspect of our work, providing vigorous, trusted, high-quality analysis, developing practical and innovative solutions informed by data and research, promoting collaboration and building consensus, and being inclusive and respectful of diverse views and experiences. The goal of the GMHCP, Justice and Mental Health Collaboration Program, is to develop collaboration across the criminal justice and behavioral health systems, from law enforcement, pretrial, courts, jails, and community supervision, to learn how to have successful partnerships that increase efficiencies and improve safety and outcomes for people with mental illness or co-occurring mental illness and substance use abuse in the criminal legal system. BJA's mission is to help to make communities safer by strengthening the nation's criminal justice systems. Its grants, training, and technical assistance and policy development services provide state, local, and indigenous nations with cutting-edge tools and best practices they need to reduce violence and drug-related crime, support law enforcement, and combat victimization. Thanks again, everyone, for joining the webinar. I will be back later. Now I am going to turn it over to Rebecca, who will provide an overview of the APA and to begin the presentation.
Thank you so much, Demetrius. The Association of Prosecuting Attorneys is a national nonprofit whose mission is to support prosecutors in their efforts to create safer communities through a more just and equitable legal system. Through publications, training and technical assistance, and legislative analysis, we serve as a forum for collaborating with our criminal justice partners across the globe and as an advocate on behalf of prosecutors on emerging issues related to the administration of justice. Good afternoon, everyone. My name is Rebecca Neville. As Demetrius said, I'm a staff attorney here at APA. On behalf of APA, we want to thank you, the CSG Justice Center team and BJA for making this webinar possible. And I also want to thank our panelists for taking time to share their experiences and expertise with us this afternoon. If we could go to the next slide. So we'll now turn to a brief background on prosecutor-led diversion programs and how that model fits and finds engaging approaches to support individuals with mental or behavioral health issues involved in the criminal justice system. Thank you so much. So prosecutor-led diversion, as defined in a very basic sense, is a non-traditional means to resolve criminal cases through treatment program alternatives in which the prosecutor is the primary entity responsible for determining the eligibility criteria for the program, deciding if a particular case will be offered diversion or if it will be prosecuted through traditional means, and setting program conditions and evaluating if an individual has successfully completed the program to avoid prosecution. We could go to the next slide. So prosecutor-led diversion has existed in some form since the 1940s and grew in popularity in the 1960s. These programs usually involved standardized treatment protocols and a one-size-fits-all approach. So you can see this in drug diversion programs or diversion programs for first-time nonviolent offenders. And often there's a checklist of community service requirements or certain number of meetings or therapy to attend to qualify as successful. However, a recent shift in criminal justice reforms and the boom of knowledge and really in recent times around mental and behavioral health issues have required prosecutors and other law enforcement to take a critical look at how this prosecutor-led diversion model can shift and fit in cases that present with mental or behavioral health issues. So there's been a recognition that prosecutors can lead and support and guide this effort, and that cases with mental or behavioral health issues really have special consideration and treatment needs that prosecutors aren't always positioned to answer. And sometimes this is simply because they don't have access to the defendant, and sometimes this is because we're not clinical experts. So particularly diversion programs involving individuals with mental or behavioral health issues demand authentic engagement and power sharing with criminal justice stakeholders and treatment providers and community partners who can provide that focused, individualized treatment and rather than the one-size-fits-all diversion protocol. So in thinking about prosecutor-led diversion, and particularly in these cases, prosecutors must consider the cross-system impact and what entities to engage. So who needs to be at the table to help create a diversion program? Here's a brief list of the parties that would be impacted by a diversion program that should be included in the planning process from the beginning. Of your defense counsel, whether that's through the defense bar or a public defender, the judiciary, social services, pretrial and probation departments, law enforcement, and the general public. Authentically engaging with each of these entities in the process of creating a diversion planning is critical to programmatic success. So when working with these different entities and trying to start a program, there are key considerations that program planners can work through. Each program will certainly be different based on the needs and populations in each jurisdiction, but these considerations here can provide guideposts to think through for program implementation. So number one, create program goals. Program goals should be clearly defined. Is your program attempting to connect offenders with behavioral health services, with behavioral health issues to services earlier? Are you trying to create safer communities, reduce case backlogs, or reduce recidivism rates? The program goals will really shape the format and the roles and responsibilities in a diversion program, so making these clear from the beginning is important. Determining the statutory authority. Many states do have some form of diversion permissible by statute, but some are also allowed by court rule or prosecutorial discretion. So determining what your jurisdiction allows and how is critical to how a program will operate and what limits exist. 3, set program eligibility standards. What will make someone eligible or ineligible for diversion? For example, is a formal mental health diagnosis necessary, or can you look at family history? Will certain offenses, certain violent offenses, be excluded from diversion? And candidate screening. This goes hand in hand with eligibility standards. Who is going to be screening individuals for participation and for their specific treatment needs? So in most prosecutor-led diversion models, this would be someone in the prosecutor's office. But in cases with mental or behavioral health issues, this may not be the best person. So choosing and looking at an entity that makes the most sense to screen individuals for a specific program, when and how they will do that, should be determined early in the planning process. And 5, mandate treatment linkages. Which treatment providers should be involved and will be involved? Will it be a standalone health center, behavioral health center, or referrals to individual treatment providers? Whichever rule is determined, prosecutors and other criminal justice stakeholders and treatment providers can create memoranda of understanding and should clearly outline each party's role. Number 6, establish compliance monitoring. Who will be responsible for making sure the defendant or the offender is following the program? Is it going to be the treatment provider who communicates with the prosecutor, or will it be the prosecutor themselves? Or will there be monthly or weekly court check-ins? Determining how compliance monitoring will be handled is very important early on in the process. Number 7, defining the legal outcomes. In setting up this program, an office should clearly define the legal outcome for successful completion of a program's requirements. So if pre-arrest, no charge would be filed, but other options could include outright dismissal, a reduction in charges, or eligibility for expungement. And finally, creating an evaluation strategy. Using data and tracking outputs and impacts are key to making program modifications, justifying a program for possible additional funding, and informing the public about your program. So program planners can engage with a research partner early who can help them identify ways to create an evaluation plan and good data collection practices. There are many benefits to creating prosecutor-led diversion programs. There's earlier diversion in the criminal legal process for individuals with mental or behavioral health needs. You can accelerate engagement with community-based treatment services, ensuring that people with mental or behavioral health needs in the criminal justice system are connected to services as soon as possible, as early as possible in the process. Avoiding collateral consequences, convictions that present housing barriers, or allowing people to remain in the community to keep their jobs and prevent homelessness. Preventing further mental and behavioral health harms caused by incarceration can help to reduce that trauma, has the potential to build trust in the system and reduce recidivism. And you can improve the use of criminal, legal, mental, and or behavioral health systems resources. With a smooth diversion program, each entity's services will be optimized and each role would be clearly defined to improve the use of their services. And now I will turn it over to Dave for the panel discussion portion of this afternoon and to introduce our panelists.
Right. Thank you, Rebecca, for an excellent overview of the area of prosecutor-led diversion and setting up some of the concepts. On behalf of APA, we thank the audience for joining us this afternoon, and most particularly, we thank these 3 fine prosecutors who not only are looking and thinking about the concepts, but are putting the concepts into action day to day, and that's what we hope to do with this presentation. So I'm going to start with the top. Jordan Shannon is listed here as an assistant district attorney, but she's from Tennessee. And we all know that there's title NV for the Tennessee prosecutors. She's actually an assistant district attorney general. So let's give her her rightful due. So let's talk about what is the general doing. She's currently assigned to the Behavioral Care Center. That's a center that she had a number of us down to look at there in Nashville. It is an incredible opportunity, and as we're discussing that diversion, that prosecutor-led, or working with the defense and getting folks out, there's going to be a video that was done by their sheriff's office because it's actually part of the jail administration, but completely different, and that'll be part of the materials. But what else does she do besides being assigned to that behavioral care center? She's on the mental health court as well as the veterans court. She also has the distinction of working in the two largest general's offices, or district attorney general's office in the state. She started in Memphis before she went to Nashville. So she's got a good feel for the differences between those two communities, especially as we talk about behavioral and mental health. Next, from also the largest office, of course, in Illinois, is Aileen Bandari. Aileen has been a prosecutor, and let's get her title here. She's an assistant state's attorney, and that would be possessive. We'll keep moving down on these various titles. But she has been there for 19 years. She has handled everything from misdemeanors to murders, and a longtime member of the state's attorney's prosecutions bureau felony training division. Why is she here with us today? She's here with us today because her current assignment is in the Community Justice Center. That is one that we hope to encourage all of you, is getting involved in community justice is looking at what are we doing about the behavior and the mental health, and how do we keep folks out of the system or divert them, especially as we get into a topic of post-arrest diversion. So we'll hear a bit about her work, but we want to give her due because of not only her work within the office, but her national work. She's the vice president of the National Asian Pacific Island Prosecutors Association. She serves on the board of directors for the Filipino American Lawyers Association. She's immediate past president for the South Asian Bar Association. She served on the board of directors as treasurer and past chair of the Judicial Evaluation Committee for the South Asian Bar Association. So I guess she is responsible for some of the judges there in Illinois, if not Cook County, and I see her nodding, and honorary board of directors for the Asian American Bar Association. So we welcome Aileen to the discussion and have a little bit from the middle of the country. So we've got the South, we've got the middle, and now I think we're going to go way down to the tip of Florida, and we have Stephen Talpins. Stephen is the chief assistant state. It's not possessive. He's the guy, state attorney, and he's in the Miami-Dade state's attorney's office. He is in charge and reports directly to the state attorney herself, and he has his responsibility for the felony divisions in Unit 4, the gang prosecution units. As it relates to this discussion, he has under his wing the treatment courts unit, community outreach division, and the media team. And he also serves in the office lead on smart justice programming. Stephen is very involved with APA and the efforts, thinking not only what are we doing and are we doing things well, but always that question of how do we do better. He's nationally recognized author, advocate, speaker on smart justice, and he's on, I think, the board of directors of 3 nonprofit associations right now: Citizens Against Drunk Impaired Drivers, Mothers Against Drunk Driving, and the National Commission Against Drunk Driving. Most recently, NIJ has recognized him. So part of USDOJ, the National Institute of Justice, he is a member of the 2021 Law Enforcement Advancing Data and Science program cohort. We are going to start with Stephen in a presentation, and also his presentation is going to cover not only the prosecutor-led diversion or the post-arrest or what can we do there, but I believe he's also going to give us an overview of what really started Miami-Dade and looking and saying, how can we do things differently, and how these cases are not necessarily or aren't best suited for our current criminal justice system. So Mr. Talpins, or Chief State Attorney Talpins, do you want to give us an overview of what you're doing there in Miami?
Well, good afternoon, everyone. I can't even begin to tell you how excited I am that so many people are taking an interest in this topic and doing so much great work on addressing the issue of offenders with mental health issues. So I'm very excited about it. Dave, I want to thank you and everybody else for allowing me to present on our program. We're very proud of it. It's been in place in one form or another for over 20 years. And despite all that, we still have a long way to go. So I'm very curious to hear what the others talk about and getting some ideas for how we can do a better job here in Miami. If you could go to the next slide, please. Next slide. There we go. All right, so let's start with our vision, because really everything we do in Miami starts with the strategic vision. And essentially what we're looking to do is set up a system with smart, effective, and responsible justice. In other words, a criminal justice system where public safety is the most important priority. You know, very frankly, I hear talks all over the country about what different offices and different law enforcement agencies are doing. And to me, it always, always, always has to start with public safety. If we're not addressing public safety, then we're not doing the bottom line job. I mean, that, after all, is the single most important thing government can do for society, which is to protect its citizens. So we really strive to prevent and deter crime. As part of this process, we recognize that we don't have all the answers. So what we do is we try to stay abreast of all the research, including all the literature on neuroscience, and we employ evidence-based practices, something we've been doing for probably the last 30 years or so. We work with and prosecute people as individuals, regardless of what they're charged with, until you get up to the highest level of offenses. We really try to learn as much about the person as we possibly can. We systematically assess and address offenders' criminogenic needs wherever appropriate and possible, rather than just their actions. And that's a critical distinction as to how we approach offenders and how others have traditionally done it. And we also look to maximize limited public resources. And we do all this simultaneously. Next slide, please. This brings me to our mental health diversion programs, and excuse me, the Miami model is what's being called the Miami model. Our programs are designed to address people with mental health issues, obviously. In or around 2000, the county, with the state attorney's support, implemented the Criminal Mental Health Project, or CMHP. Prior to that, we had been addressing people on an ad hoc basis, but we hadn't formalized any of the procedures. And for those of you who are more conservative and appreciate the traditional approach to criminal justice, I'm going to tell you a quick story. When we first started looking at this program, I was the chief of county court in 2001. We first started implementing it on a wide scale in the courts. I was asked about the program, and my response was less than enthusiastic. That, of course, should tell you a lot about me at that particular stage in my career, that I was less than enthusiastic about a program that was being led in large part by the state attorney, my boss. So I was asked to give this thing a chance, and I did. And 6 months later, I ended up supporting this program wholeheartedly. And I share this with you in part because I think the conservatives among the bunch can support the program once they see the research like I did, and once they realize the fiscal impact. One funny part about this story is after I came out and supported the program, the public defender's office then questioned what rights I was depriving their clients of, because if I supported it, there must be a problem. So that was kind of an amusing turn, which led me to believe that we have to do a much better job communicating how these things work to all of our partners, all the stakeholders, and making sure we get buy-in from everybody before we get too far down the road. Anyway, since that time, our program's been an unqualified success. It's promoted public health and safety and saved our county millions of dollars annually. It also serves as a national model. And again, for you conservatives out there, it literally saves us millions every single year. As to what that amount is, there's some debate, but the bottom line is we're saving a boatload of money, and the results have been really, really positive. You're going to see at the bottom of every slide, I give you a site where one exists, so you could go pull the research and articles yourself and get a better understanding of exactly what I'm talking about and see how it actually works. If you go to the next slide, please. So we employ a two-prong approach at this point: a pre-arrest program that relies on crisis intervention team, or CIT officers. For those of you who are familiar with the Memphis model, that's exactly what I'm talking about. We use the Memphis model. We also employ a post-arrest diversion program. Next slide, please. The CIT program began providing training to our officers in or about 2000 with funding from the National Gains Center. But the program really took off after a grand jury did a report on mental illness in the criminal justice system in 2005. Since that time, we've now trained over 7,000 law enforcement officers in Miami-Dade County. Next slide, please. Our CIT program is based on the Memphis model. It's a collaborative effort involving all the stakeholders with buy-in at the highest levels of local government. Buy-in is really critical here. If you are at all interested in this kind of program, you got to make sure you get buy-in from everyone, and particularly our offices, the DA offices, the state attorney offices, really have to be heavily involved. In our program, we emphasize knowledge, training, and regular communication. Our officers meet with providers on a monthly and a quarterly basis to make sure they're keeping up to date with everything they need to know. We're constantly expanding our ability to share information and data. We know that's the only way this program is going to get through. We also know that inevitably there's going to be a problem. Something is going to go south. When you have a large program, it's never going to work perfectly because nothing created by man ever will. We know that. So we collect as much data as possible so that if something does go south, we're then able to show that it's an anomaly and that the program is really working well and is having a huge impact on public safety. At this point, as far as we've come, we're still looking to move toward a co-responder model. So it'll be a hybrid between the Memphis model and a co-responder model. What I mean by that is we'll have CIT officers show up on the scenes, but we'll also have co-responders show up on scenes when appropriate. Next slide, please. This is one of my favorite slides. There's been a lot of talk about defunding the police and shifting responsibility from the police to other people, particularly in the context of mental illness. And I like to show them this slide whenever this comes up in Miami. This is a slide that shows data from our two largest police departments, the Miami-Dade Police Department and the City of Miami Police Department. You'll see it contains data from 2010 through 2019 inclusive, although some data is missing from the City of Miami as indicated. So they responded collectively to over 105,000 calls for crisis intervention. That's a lot of calls. Unfortunately, we have a huge mental health issue in Miami as the data reflects. We're doing our best to address it, but obviously have a lot of work to do in that area. But the critical things to point out on this slide are the following. First, in terms of arrests, 105,000 calls, less than 200 arrests. So when the narrative is told that officers are out there arresting everybody on all these scenes, that simply is not true when they're trained properly, like they are in Miami, and when the leadership believes in alternatives to arrest like they do in Miami. Of the 105,000 cases, over 18,000 of these people were diverted from jail. 66,000 were transported to crisis. Use of force used only 564 times. I like to point out that the use of force was well in excess of arrest. And I do that because it drives home an important point. The officers aren't even arresting all those people who respond violently, which I find fascinating. There were 122 cases where officers were injured. Pretty low number, very reflective of the good training they have and the way they're taught to de-escalate situations. So all that data runs very contrary to the argument out there that police should not be responding to these calls. Next slide, please. I want to talk to you for a couple minutes about our post-arrest diversion program. Excuse me. I'm going to share with you some of the highlights. We have a whole bunch of different programs, but this is what they essentially boil down to. We have a pre-adjudication program for people charged with misdemeanors who suffer from certain types of illnesses, including schizophrenia, bipolar disorder, major depression, or post-traumatic stress disorder. And it's for people also charged with lower level felonies, and we can even throw in some other charges as appropriate. We also have a veterans treatment court, although that's not addressed in this particular program. Next slide, please. Other highlights include the parties, court, and providers work together to create an individualized treatment plan that provides a full array of necessary services that are designed to address the particular or individual offender's criminogenic needs. These can include all the following: intensive case management, that's always included, treatment for all conditions, which is provided to the extent that we can, trauma support, peer support, housing, education, and employment opportunities. Next slide, please. CMHP personnel screen all the participants for eligibility for federal benefits and help them apply for the services they're entitled to as appropriate. I know there are a lot of other programs out there. If your program is not doing this, you really need to look into it. It's a huge, huge benefit and could defray a lot of the costs of the program that your system may currently be bearing. Additional income from SSI and or SSDI can also help facilitate the participants' rehabilitation by providing them with a steady income as well as health care coverage. With CMHP's help, 78% of the people who apply for benefits are approved on their initial application. To give you an idea of what a big deal that is, the national average is only 27%. The average time to approval for people in our program is about 40 days. The process typically takes 9 to 12 months. So not only are we doing everything we can to help them, but the folks that are doing it are doing a very good job in the process. Next slide, please. In 2019, 222 misdemeanor and felony offenders participated in one or more of our post-arrest mental health programs. Misdemeanor program participants' recidivism rates decreased from about 75% to 20% annually, huge reduction, and felony program participants saw reductions in jail bookings and days by more than 75%. Does the program work? You bet it does. Next slide, please. Our program is working, but as I said, we're still not done. In addition to looking at a co-responder model for the CIT program, we're also developing a new forensic facility that'll provide a one-stop shop that provides all the essential elements for recovery in one location. It'll have an integrative crisis stabilization unit as well as addiction receiving facility. It'll have various levels of residential and outpatient treatment, including vocational rehabilitation, supportive employment services, educational spaces, medical care. Certain medical care will be limited to dental, vision, and podiatry. Treatment services, day activities, which are very important to keep people busy and let them find something that they enjoy doing, as well as supportive educational training and housing services and opportunities. Next slide, please. The construction on the facility began on March 31 of 2019, and it's scheduled to open in March of 2022. Capital funding is being provided through the county's general obligation bond program, as well as Jackson Health System, the public health trust. Next slide, please. So this is what we've learned. Smart treatment of people who suffer from mental illness actually works. It can significantly improve their lives, as well as improve public safety by reducing recidivism and keeping them out of jail. We believe that by working together, we've proven that we can decriminalize mental illness, we can improve public health, we can improve public safety, we can help officers address people in crisis more quickly, efficiently, and safely, and we could save critical tax dollars. And we could do all this at the same time. Gets no better than that, folks. You could do it too. Thank you. Dave?
Thank you, Stephen. Very, very impressive, and that's exactly what we're trying to do is get folks the information they need to make changes in their office. And I just posted in the chat box for the audience. Please use it because we can either get you some answers now during the presentations, or we can get back with some answers and some things to follow up. I think, Eunice, if we can go back to slide 18, that will remind us of who we have here presenting and talking. And at this point, I'm going to turn it over to Aileen, because let's hear what Cook County's doing now that we heard from Miami.
Well, thank you so much. I don't know how I'm going to follow that presentation. I don't have a slide. But in Cook County, there's several different things. Like you said earlier, I work for the Community Justice Center in the Cook County State's Attorney's Office. And so those formed almost more than 20 some years ago. And there are 4 centers. And the purpose of those centers is to do problem solving, as well as to create safer, healthy, thriving communities. And so the thought process is kind of what was an alternative to prosecution, right? Sometimes the problems that were coming up in the community was it always going to be solved by arrest and prosecution? So that's what we try to do. We do a lot of programming in the communities. I work with a lot of faith-based organizations, community organizations, nonprofits, to come up with programming. So we are trying to do crime prevention and violence reduction, trying to figure out how do we keep programming going, what type of things can we do on the ground to prevent crime from happening, what are the resources, what are the needs of the community that we're in. Then the way the communities have been identified was through partnership with the Community Policing Office from the Chicago Police Department, and we targeted particularly high crime or high volume communities with violence, those particular police districts. So I am on the west side of Chicago. I cover the 15th and 25th police district, and we have 3 other centers that have particular police districts that we cover based on the amount of crime, the type of crime, the pressures of violence. So part of us in the Community Justice Center is to identify who are the pushers of violence and how can we take those cases and prosecute those cases. But we also, on the other hand, are trying to figure out why are some people are leaning towards crime. How can we prevent them from getting into the doors of the courtroom, so to speak, and try to get to them before they've interacted with the criminal justice system. But we're talking about mental health here, so how that works with the state attorney's office is it is by statute. There is a statute here in Cook County. It's the mental health, called the Mental Health Court Treatment Act. It tells us who's eligible and how they can become eligible, what happens in mental health court, and essentially is the chief judge is directed to have a mental health court. There's going to be mental health court professionals. That means there's members of, this is not the judge, it's going to be a prosecutor, defense attorney, probation officer, there's a coordinator, there's treatment providers, there's a peer recovery coach, and all of these people are working together depending to try to help the person who's been entered into the mental health court. A little bit differently though, it is not plea, it's post-plea. So this is after someone has already been arrested, you're in court. It can be for misdemeanors and it also can be for felonies. And the way people get screened for mental health court is you do have to have a diagnosis to be in mental health court. And so once someone is arrested, the state's attorney, we have the state's attorneys who are specifically tasked with our diversion program in our bond court. And they are the ones that actually will review the file as it first comes into the court. They'll review someone's background, see if there's any type of treatment that's ever been issued, or someone has a diagnosis as their medical history is available. And they get screened out for mental health court. And a lot of times, though, it's going to be the defense attorney or defendant's attorney who's going to say to us, my client has a mental health issue, and then we have to get their medical records, their diagnosis, and then they get screened out to mental health court. So this program is post-adjudicatory, meaning the defendant has admitted to guilt or has been found guilty and agrees to go along with the prosecution to enter into a mental health program as part of their sentence. And sometimes the mental health court program also means it can be also co-occurring with our substance abuse court, meaning that it includes someone who has a mental illness and a substance abuse problem, which is what we find a lot here, is to treat a person wholly. So the chief judge here in Cook County in each judicial circuit can establish a mental health court here in Illinois, and the eligibility for the defendants really depends on their background and the type of crime they've committed. So we do not, they are not allowed to have a violent crime in their background. So if they have a violent crime in the last 10 years, or the offense of a violent crime, such as murder, second-degree murder, predatory, sexual assault, kidnapping, great bodily harm, or discharging of a weapon, those make you ineligible for mental health. Or if your the crime that you've committed is non-probationable, you're generally not eligible for mental health probation. So that then leaves it upon the prosecutor to make a decision regarding what their final charge is going to be. If it's like a class 1 drug case that maybe someone was dealing, usually that's non-probationable. So the state's attorney has the ability to sometimes amend the charge to make someone eligible for the mental health court, depending on the circumstances, depending on their background, depending on their diagnosis. I think a lot of times, also in our misdemeanor program, this is people are also eligible for our mental health treatment court post plea. And so usually it's 24 months of intensive probation. We focus on treatment, medication, medication compliance, housing, and employment opportunities. And the mental health court, they target high-risk, high-need persons charged with nonviolent offenses that are generally eligible for probation. And once they complete this for the misdemeanors, charges are generally dismissed upon successful completion of the program requirements determined by the case manager. And so it's a little bit different from the felony court because the felonies, they're a little bit more serious in crime, but charges can be dismissed upon successful completion of these program requirements. They have to have a felony charge. They have to be violent. They have to be willing to participate, and they must have a psychiatric diagnosis. So that is what happens when we have the mental health. Someone has been arrested and placed into the criminal justice system. Well, here in Chicago, the Chicago Police Department is also trying to divert people out of that criminal justice system when they first encounter them. So there have been strides in having like a crisis intervention team. That is beginning. They've come up with a set of officers that are being trained as crisis intervention. Also, they are being sent out with someone who is like a mental health facilitator or who has that type of training to go out on some type of calls when it's been identified that the person is in mental health crisis. And so that when the officer's responding, when someone from the mental health crisis team is responding, they can kind of direct them out of the criminal justice system before they even get to court, depending on the nature of the offense and depending on what's happening, in that particular case. Particularly for me, though, on the criminal, the community justice center, if someone is having, sometimes people are committing crimes here at the community justice center, and it's not always apparent that there is a mental health issue, right? It's not someone that's being diagnosed with, that's having a psychotic break or that has a diagnosis. It is people that are committing crimes that have had post-traumatic stress, that are reacting badly to the death of a girlfriend, and so now they're drunk driving, and they've gotten several cases, and they're having issues. And so unless, what I try to do is, it's almost like case by case, to work with a defense attorney to see what is going on behind the scenes. If you look at the case of itself, generally in the courtroom, it's going to be, this person is driving drunk, this person has a gun, how are we going to deal with keeping the public safe? But if you kind of pull that screen behind and talk to the defense attorney and say, what's going on with the client? Well, his girlfriend was killed, was shot to death, he's taking care of 2 children of his own, he's going, he lives in a rough neighborhood, he's trying to get his barber's license, and he was going off on benders, and that's why he was driving drunk. So now we have someone that has a mental health issue, that might be dealing with post-traumatic stress, that has a substance abuse issue. And then on paper, it's just someone who's got guns to the car and driving drunk, but behind the scenes, it's just someone who can use some type of different alternative treatment. And generally, the sentence for those types of crimes that I've laid out will generally give you the ability to have mental health treatment or mental health treatment court. So as a prosecutor in the community justice center, I would have to see how I can get help to this individual using my community resources that I have, my nonprofits that I work with, particularly in the West Side, any faith-based organizations, to get this person assistance and to kind of steer them clear from the criminal justice system so that they can kind of be successful, they can be a contributing member to their community, and that we have a safer, healthier, and a thriving community that, that they can live in, and that now this person might be raising, children. Sending this person to the Illinois Department of Corrections may not always be the solution, because then the child is without a mother or without a father. So we have to kind of think of those things a little bit more holistically, a little bit broader. And that's some of the things that we're doing here in Cook County.
Aileen, thank you very much. And thank you for also pointing out how important this is in the community. Like, how do we do this right? How do we engage that community? Well, Jordan, last but certainly not least of the various programs. In fact, I know Miami had a lot of slick stuff, but you're the one that you actually have a big behavior care center. So what would you like to share about life there in Nashville, Tennessee?
Okay. Thank you. Well, I thought I would just tell everybody about our specific behavioral care center and how proud of it we are. Essentially, what happened in Davidson County was that we had a sheriff that was very invested in decriminalizing mental illness. And so he approached Glenn Funk, who is the elected, and the two of them got together and started talking about the sheriffs want to build an actual facility to house people who are arrested that do have mental health issues. And the District Attorney General Funk, he was totally in favor of this, and he worked with the sheriff, said he would staff it. So there I am. And they met with the public defender as well, the chief public defender. She said she would staff the program. So we met over the course of a couple of years to try to plan out what the behavioral care center was going to look like and how we were going to run it. So first, I thought I would tell y'all a little bit about what is the behavioral care center. And basically, it's a 60-bed adult supported residential facility, and it provides gender responsive behavioral care services to residents in a short-term residential setting. And when we say like a residential setting, like an example of that you can see in the video that Dave mentioned is that the correctional residents, if they're there, they're wearing scrubs and a different instead of a uniform, and the inmates are wearing a maroon uniform instead of the typical orange, and basically it just sets them apart and has more of that rehabilitative feel rather than a coercive jail feel to it. It is designed to only to house residents for a stay of 30 days or less. And what happens is upon each person's arrival to BCC, the resident is assessed by a team of mental health care professionals who come up with a treatment plan specific to that particular residence and their needs, which can include group and individual therapy, medication, which is prescribed by they staff a nurse practice, psychiatry nurse practitioner who looks at their medications, prescribes new meds, and manages the ones they're already taking or have taken in the past. While there, they meet with the discharge planner who addresses their specific concerns and needs, and will set up housing for them, get them a bed at an inpatient treatment facility for once they're released, anything like that. And the residents aren't released to the street with no support. They're actually going somewhere and they have as much of a plan as humanly possible in place. So they don't just walk out right back to where they came from. And then the people that work at the behavioral care center follow up with every participant every 30, 60, and 90 days out to see what's going on with them, if they need any more help, if they need to be reconnected to doctors and things of that nature. So that's basically what the facility is and what it's staffed with. But the way that we have gone about running it, which has been a learning experience day to day, is that essentially every single inmate that comes into custody and gets to booking is screened for the BCC. And that is staffed by the mental health cooperative. We have specifically trained staff provided by their office who work in booking, and they are there to weed out people who come through booking and identify either a prior mental health diagnosis or present concerns. If it's a prior mental health diagnosis, then we verify that by reaching out and getting any kind of documentation of that diagnosis or prior treatment. If it's never been verified before, then we do look at those people as well. They make our list, just not quite as strongly as the ones we can verify immediately. And that list through booking, so everyone overnight, comes to a PD and myself every single morning at about 6 a.m., 6:15 in the morning. We get everybody who screened in that was arrested overnight. And then I personally staff every case with the PD's office and the sheriff's office, people from the BCC who also employ a person that helps run the program there, who is a licensed clinical social worker from the mental health cooperative. So the four of us, the head of the BCC from the sheriff's office, the young lady from the mental health cooperative, the PD, and myself, the four of us sit down at a table every day and staff the list from the night before, if that makes sense. And basically, I am looking I'm not looking very strongly at the person's history, their criminal history. I'm really looking at the charge that's before me. I am trying to find someone who's not on probation or community corrections out of criminal court, because that can complicate matters. But as far as the actual charge, we are taking them on a case-by-case basis. So I believe the highest level of crime I've taken at this point has been ag assaults and ag burglaries. So in Tennessee, those are C misdemeanors. I'm sorry, C felonies, excuse me. So we have taken those crimes, but I will look at any case on a case-by-case basis. And basically, the idea is that the state, on the cases that we choose, we tell the public defender, okay, this is the person we'd like to make this offer to. If this person will will participate in the behavioral care center program and completes it successfully, then the state will nolly their case. So the term nolly means, as you've probably heard it pronounced a few different ways, but like null pros, nolly prosecui. But in Tennessee, the state has the authority to prosecutorial discretion to decline to prosecute a case. Now, initially, we wanted this to be a process that was pre-booking, but Tennessee is an officer charge state, so there is not a prosecutor there to review every single charge before an officer takes the charge. The officer is the one charging the cases. So unfortunately, we haven't been able to do it that way, but we've done it this way so that the point is that the defendant never hits a courtroom, never has to be in front of a judge. They're in front of a magistrate initially when they come in. We pull them and get to them typically before they have been taken over to court, gone through that court system, because the point is to avoid that. So when we enter this, we had to figure out, how do we get rid of these cases, because we can't dismiss them without judicial involvement. So that's when we came up that we would put in a notice of nolly, which is just the state's intent not to pursue this case. We turn those in, I sign it, date it, turn it into the clerk's office. They enter it into the computer and put in a release for the defendant. And that's the way that they are released from the BCC and never going into a courtroom. Right now, unfortunately, when Dave came to town, we were running at a 7% recidivism rate, which I was very proud of. However, the hotter months have brought us up to an 11% recidivism rate. Still very proud of that. Incredibly low considering the type of the demographics that we're looking at, which are people who have, charges going back a billion years, just misdemeanor charges, and our regular offenders downtown especially. So we're still very proud of that recidivism rate, and hopefully it will stay low. And just really proud of the program altogether. And for us, it's the results we've seen have been really amazing. We've been up and running for under a year, so I don't have great stats for you other than to tell you that the low recidivism rate. I'm hoping that it will continue to grow. We'd like to expand the facility. It's beautiful, and I hope that you all enjoy seeing the video.
Jordan, I think you do have statistics that everyone should pay attention to, and I think reinforcing 7 or 11% recidivism on folks that before, how many times were they booked, or as you said, they were being booked, charged by your law enforcement, being a police charging state, so there were charges levied against them, these individuals, and then ultimately released and back out again. Like, can you give the audience a little bit of a taste of the very, very difficult group you're working with?
Okay, so in addition to doing the BCC every morning, I then hike over to court and do the misdemeanor review docket, which is all of the misdemeanor cases who are arrested overnight. So what I'm seeing are people charged with misdemeanors who, in Nashville, where right now there's bail reform, bails are very, very low, and pretrial release rates are extremely high, and that's where a defendant doesn't have to make a bond at all. So that's what I'm kind of up against and pulling from this pool. So what's left over are people who are, so disadvantaged to the point where they can't make $100 bond on a criminal trespass charge because, they're homeless. So I'm going up against a lot of that. Nashville has a huge entertainment district downtown. We get a lot of out-of-towners who come in and get into some kind of trouble downtown, and are transient. So we're up against people who are not well established with roots locally, and they don't have any family to come and bail them out, that type of thing. And so I'm looking at this particular group where we literally know these people's names, know their faces. I have some people right now that I see arrested up to 3 times a week, which is really unfortunate, but it'll be a Monday, Wednesday, Friday type arrest for them, where I'll let them out. They'll be right back through the door. So those are the people we're trying to intercept.
Excellent. And I think the other piece that you're doing that you didn't mention is the reentry piece. Those that have been in jail for a period of time. I think it's the last 30 days. And I think this will go, and I'm going to ask for Aileen and Stephen to put their cameras back up, because now I get to question you a little bit. But Jordan, I was thinking one of the questions that has come up is non-compliance with taking medication. And
sure.
Especially the reentry group, as well as those going to the BCC. How do you assist them in taking their medications? And then, and it will be a question to the other two, what happens when they do not take their meds or they go off their medications? So
currently, what is a challenge for us is that in order to come over to the behavioral care center, the client themselves must be competent enough to sign an agreement that states that they will follow these basic rules while they're at the behavioral care center. One of those rules is to be med compliant. So if they are prescribed medications, they agree that they will take them while they're there. We are able to look at the referrals that I get. I didn't mention, but in addition to the morning referrals, I get referrals from defense attorneys, things of that nature throughout the day that are more non-traditional. We're able to actually look up their jail records and see if they are or are not med compliant. If they're not, then they're not a good candidate for the BCC. Oftentimes their defense attorney will speak to them and let them know, if you don't get med compliant, then this is not an option for you. And sometimes that brings them into compliance. And with the reentry group, they would not be brought over until they became med compliant. That's where we're at right now. We wish that we didn't have to stick so strictly to the lines of the of them being able to sign that agreement themselves, but we had to draw the line on that at the way that we're currently running the facility. We'd love to expand it and have the competency training and some of their forensic evaluations actually take place at the facility. We're just not there yet.
Excellent. And I also thought for the group, the fact that you do a warm handoff as it relates to the medications, those that are on medication, they do not leave the BCC unless they're going somewhere. And I believe you're also sending them home with their medications a certain number of days. I don't, do you do 30 days medications? What do you do on the meds?
30 days supply. They get sent home with a 30-day supply of their medications. They're always sent with that, even if they're going to a treatment facility or anything like that. They get that 30-day supply to go with them. We have released to family members. We've released to rehab programs. We've released to homeless shelters. In some cases, we've released to a variety of places, but they're always going to have the meds and have the appointment with their doctor set up.
Okay, and Aileen, get ready for these questions also, but I'm going to keep, I've got 2 more for Shannon. So completely outside this topic, there are questions about the autism spectrum. What do you do with folks that are on the spectrum and with the autism disorder? Anything you'd be willing to share?
Sure. That is, I would say that falls into the wheelhouse of those employed by the mental health cooperative that work at the sheriff's office with this program. We would have them actually meet and personally what we'd call screen or interview that potential person first. And then because they're the licensed clinical, social workers, they have the educational background and training to kind of get a grasp on if this person could be successful at the behavioral care center, because we don't want to set them up for failure, and autism can be a very a tricky thing. So I hate to say we leave it to the professionals, but to be honest, we do in a case like that.
Perfect. And then my promised last question, and this is excellent coming from the audience. It's a long one, but I'm going to read it because I think it covers a number of things.
Okay.
Panelists have described pre-arrest law enforcement assisted diversion, pre-charge prosecutor-led diversion, court-based pre-plea and post-plea alternatives to incarceration, the treatment courts, and post-sentence incarceration, the corrections-based programs, or you said your reentry. And they've been reading our materials. The sequential intercept model encourages access to services at every stage of the criminal justice involvement. But should we be clear about who leads which model to promote coordination and avoid duplication of efforts and interagency conflicts? So hope the other two panelists also heard that very long question, but pose that to you. Jordan, how do you work with the various intercepts? And you already do not have an opportunity, as you shared. You can't get to the pre-arrest. Our other two folks are working in that environment. But how do you make sure you're not duplicating each effort? You've also said things like, hey, the defense attorneys come to me. I think when we were there, we were told also sometimes the corrections officers say, hey, this is a really good candidate. We want to get him out of the jail and get him into behavioral care. And I also want to reinforce, they're not prisoners, right? They are patients. They are not in the jail jumpsuits. The sheriff personnel are not wearing any sort of uniforms, or their uniforms are scrubs. So you're getting them into a whole different world. But on this, how do you coordinate? How do you, these are a lot of balls in the air, and different people have different controls at different times.
I think that we found that the best way to coordinate these efforts is just to keep an open line of communication between limiting it to myself, the key public defender, our person from the mental health co-op employed there, and then the supervisor, who's the one that's going to get the security clearance, because, unfortunately it is still, it's not jail, but it is jail to a certain extent. We have to get that security clearance from that end. The four of us, we have made it known that we are the people to reach out to with different referrals about different people, and that we will discuss anyone and everyone that's brought to the table, and we do. So I think that by mainstreaming, or I guess by kind of making sure that the same person isn't getting bounced off a bunch of different district attorneys or a bunch of different public defenders, and they're passing it around and, trying to get one outcome over here and one outcome over here. We say, no, we got to go through myself and through the public defender, Mr. Morris, talk to us, and we'll bring it at staffing the next day. And that way, I think we've made sure that everybody is on the same page. Also, we're very open as far as email and communications and things of that nature, that we include everybody on non-confidential, of course, communications about a person's status as far as screening and what we know so far as the case goes, and when we could get them moved to the BCC, that type of thing. So I think you just have to have those open lines of communication, and maybe not too many cooks in the kitchen.
Sounds perfect. I'll get you off the hot seat. Let's make Aileen work a little bit. So Aileen, let's start with there. And especially, you're in a massive office, and I think for the audience, not only do you have Chicago, right, the Chicago PD, but you're working with, and I don't want to have the wrong number, 30, 40, 50 different law enforcement agencies. So on this question of all these places for intercept, how do you do it, and how is it coordinated? Or maybe perhaps that's the importance of the criminal justice or your community safety model.
Well, once someone has entered to the mental health treatment court, it's a specialized unit in our office. So it is staffed by the same attorneys, and there are judges that have the mental health court. So they run a regular courtroom, and then they have these particular judges that are assigned to these cases. And there is a team of people that are working with the judges. So they're meeting the people that are working in these programs, whether it's the coordinators or the mental health providers, the public defenders. They are meeting together before court, and then they are in court on the days that the cases are up as they monitor each defendant. And so there's a veterans court and there's a mental health court in Cook County. We have 26 in California, which is the main courthouse, and then there's 5 other districts, what we call our suburban courthouses. And so there are state's attorneys that are assigned to those, what we call the diversion program, or the mental health court, or the veterans court. They are assigned to those divisions particularly. So, and they've been there for a while, so that they are familiar with all the defendants that are coming through and all the cases. And if there is one case in one courthouse and one in another, then there's going to be coordination between the state's attorneys. And so, for example, even for me in the Community Justice Center, if I pull a case for a pressure of violence, and this person happens to have a case in another courtroom in a different side of town, I'm going to ask to take that case as well, even though it's not something in my district, because now I can deal with the defense attorney on one defendant easier. So there is a coordination with the staff, with the judges, with all the personnel in these particular courtrooms, and they're meeting regularly. And they pretty much they've been there in place for a while, and that kind of helps with the consistency of what's happening with these cases.
Okay, and then a very quick follow-up on that, because that was something else that's been asked, is how does prosecutor-led diversion and PLD and as you said, your community justice center, so you're keeping some cases out or doing some alternatives with it. How does that coexist or complement the mental health court, the more formal mental health court? How does that work?
Well, I think for me, for the Community Justice Center, because it's private, the defense attorneys may not know to ask for it, right? They're not going to know that, hey, Aileen, or the CJC, what can you do for my client? It's, I might be taking someone who has an armed robbery conviction and realizing this person has committed an armed robbery because they had a mental health issue, they were on drugs, they couldn't find Pampers for their child, and they decided to commit this crime. And once you're taking a look at that individual for the case and what happened in that case, I can take that case and do something different with it, working with my community partners. So that's really prosecutor-led. In a courtroom, traditionally, an armed robbery with a dangerous weapon is going to get 6 years, Illinois Department of Corrections. You're not going to get mental health treatment on that. You're not usually going to get drug treatment on that, depending on the facts and circumstances of that case. When that case gets to the courtroom, the state's attorney in that courtroom is going to look at it for what it is. In that particular case, I might have to reach out to the victim. I might have to talk to the victim on that case, see if they're agreeable, explain the situation, have the defense attorney prepare something regarding the background of the client, so that we can do something alternative. But in those cases, you kind of have to look to see, is there something underlying? Is there a mental health aspect as to why people in the community are committing or going down this path? Is there trauma? Is there a mental health issue? You don't know that when you just read the arrest report. You're not going to know that by just looking at the case report. You can't know that. So it does require you as a prosecutor to kind of go that step further and ask the question. And having to work with a defense attorney closely, and having them have the ability to trust you, that you're not trying to jam their client up. I'm literally asking, like, what's up with your guy? What's up with your client? What do they need? How can we make this person not come back into the system? What services are available? A lot of it has to do with mental health. A lot of it has to do with drug treatment.
Okay. And then the other two questions that I promised you, the autism spectrum and autism disorders. What, if anything, are they eligible for your programs, or what do you do with folks that are on the spectrum with the disorder?
I think that, when it comes to the autism, depending on how it reveals itself, if it's been diagnosed, if there's an ADHD along with it, or if there's other, if it exhibits itself in other ways, it can, if they're on certain types of medication that kind of controls the behavior, that can also be considered to be part of the mental health. It depends if someone who's committing crime also happens to have this type of diagnosis. So if it is possible, if they do have it, then they are treated. But I'm not familiar exactly with any particular case that people, have exhibited autism, particularly that are coming into the criminal justice system. It might be being dealt with differently.
Okay. And then finally, probably the more common question, medication. How do you keep folks on, once they're stabilized, how do you keep them on their meds? And what happens if they stop taking?
Well, for us, it's a 24, generally the mental health court, I mean, it can be extended. It is generally a 24-month probation program. So you're trying to keep them on their meds, you're trying to keep them monitored, that they are taking it, that they are checking in, they are going to their, mental health facilitator and the coordinator, and that they are doing the things that they're supposed to be doing. Many of the people that we are dealing with, if you're in custody, they can monitor that in custody. But if you're out of custody, that's going to be prevalent or reliant on that individual to be doing that on themselves, and then to be dealing in that team effort to say, are they able to do this on their own, and are they doing it? If they don't do it, there is some leeway. Obviously, the court and the judge is trying to get individuals to be on track. So there is some leeway given, but at some point, the defendant has to agree to this. If they don't, then that is a violation of the court order. That is a violation of the order, and there's a consequence to it, right? If you cannot, maybe you're not in mental health court. Maybe you get, you have to then get incarcerated so that you are then put in a treatment program. So there's out of custody treatment and in treatment, and so our kind of the goal is to hopefully be able to get them to do it out of treatment. But certainly there are treatment programs that are in custody, which is also an alternative.
All right. Poor Steve Talbot is out there waiting, saying, "Put me in, coach." So Eunice, can we go to slide 33 to get some kind of general questions up there? But Steve, let's start with the last two questions. What do you do about having folks on meds, as well as autism and the autism spectrum? What is Miami's solution?
Well, if you don't mind, I'll start with the autism question. And Dave, I'm sure you know why. I will share with you all, I have a 14-and-a-half-year-old boy who is autistic, who has dramatically impacted my view of criminal justice and mental health issues. Fortunately, he's doing exceptionally well, but his thought processes are so different from what I have encountered throughout my life until now that it's forced me to better recognize that not everybody looks at things the same way. As you would expect, I'm very sympathetic to people with autism and other mental health issues. I've got some close family members and friends who have various mental health issues as well. So we go out of our way to work with essentially everybody. One thing I did want to mention is, as I was listening to the answers by everybody else and to the way the questions are framed, is we view this as a whole continuum of services for different types of people who have different needs. And the reason I say it like that is because we don't confine how we address these needs and these individuals in just our mental health court. And yes, we do have one. We don't confine it to just the CIT program or pre-arrest diversion or post-arrest diversion or post-adjudication programming. It's really in everything we do. So for example, if I put somebody on probation who has special needs, we will try to address those needs as a condition of probation, even though it is not formally a part of our mental health program. Does that make sense?
No, that is excellent, and I of course knew about Sammy. I also think for the audience that there's a national movement with the autism, right, to get a bracelet, and on that bracelet, description as well as the key contact person, because so often, in the encounter, if you can get to the contact person, you can diffuse. But I don't know if you want to share anything on that. But that is one of the movements that have been happening, and maybe that goes right to a number of specific Miami questions. And one of them was, as it relates to the CIT, who does the training for the police officers?
Our CMHP actually is responsible for all that. Our office is not at all involved in that. So I can't provide further information on that. If you like, I could certainly get an answer and provide you with more information, which you can then distribute to the group as to the specifics of it.
Perfect. Then another Miami specific question, and don't worry, I'm going to get to the end about how do you coordinate all this. But with the CMHP in Miami, do you only look at the charge, the current charge offense and the diagnosis, or do you also look back and see if there's prior violence? I think Elaine talked about if there's violence, that's really hard.
Yeah, we basically look at everything. If the current charge is a violent charge, obviously that's something we have to take into account. Remember, it goes back to what I had said earlier. Our first and foremost priority is protecting the public. And if that means we have to incapacitate someone for a long period of time, we're going to do that. It's really that simple, and it has to be, because that's our primary responsibility. That said, we will, in appropriate cases, put people into our various programs at one stage or another, even if they've committed an act of violence. An example would be, we even get situations where people interact in a violent or non-compliant way with police and don't even make it past the CIT stage. They're Baker acted, and that's the end of it. Once they enter the system, once they're actually arrested, we take into account essentially everything. And I mean literally everything. One of the most important things to us is whether or not, in a violent charge context, if the victim is injured and what the victim's position on sentencing is. We'll always take that into account. So, in Miami-Dade, a lot of people are very aware of the mental health issues plaguing our community and give us a lot of ability to work out cases that may not be so workable in a more conservative jurisdiction.
Understood. And then finally, and I've eaten into 3 minutes of Demetrius's time, so I do need to pass this to him. The idea of the coordination, and especially how can we have coexist prosecutor-led diversion as well as mental health courts? How do they not step on each other, or the coordination role?
Well, our goal is to intervene at every potential stage of intervention. So it occurs on the streets with the CIT program. It occurs in a pre-adjudication kind of way. Pre-adjudication diversion is something that only the state can agree to. That's us, the state attorney's office, the prosecution. So that's clearly going to fall within us. Even once we divert them, though, the court has a very active role in the program and essentially leads the program from there. In post-adjudication, we put the person into the program as a condition of the plea, and the court controls it from that point forward. So really, for us, it's a collaborative effort from start to finish. Everything we do here is collaborative. Part of the advantage that we have is we've had a state attorney in the position for almost 30 years. So we've got all the relationships that take most jurisdiction years to build. Everybody's worked with each other for a very long time. We trust each other. We all know that we're in it for the right reasons and that we're going to do everything the right way all day, every day.
Perfect. And I think you kind of laid it out. Police leadership, prosecution leadership, and court leadership, best interest of the patient. With that, I want to thank the three of you. Thank you for everything you shared in your offices, volunteering to be a part of this panel today, and as well as the audience. Thank you for your participation. Demetrius, I think this goes back to you for some final thoughts and some final questions.
Yes, thanks everyone. And thanks all the panelists for participating, and as well as the attendees for all of your robust questions. The questions were coming in fast and furious. I didn't even have to go through the piece of the slides that asked you to post your questions in the Q&A panel. You all were already on that. So I think if you asked a question and it hasn't been answered yet, I will ask that you share that in the Q&A panel as I go through the closeout, the remainder of the closeout document. So Eunice, if you can just jump to slide 36 for me, that will be great. Okay, and again, attendees, if you asked the question that hasn't been answered, if you can just, again, as I'm going through these slides, put that in the Q&A panel, and we'll try to get to that, given though we only have 4 minutes left. So this slide here is a set of resources that we wanted to offer you all. If you all are looking to either begin your prosecutor-led diversion or work with your prosecutors in your areas in support of a behavioral mental health diversion program. Next slide.
Demetrius, can I slow us down for 30 seconds? Because I think there was an excellent question by one of the judges
Absolutely.
about timeliness. And
Absolutely.
I think because it's from a judge, we respect the bench. It says here, I'm a judge in Massachusetts. Some of the local DA's offices have set up post-arrest diversions, which is good. And many of my colleagues are fans of diversion programs. One difficulty we see is making sure the cases being diverted are processed in a timely manner. We regularly see diversion cases that are months old with the arraignment delayed, but we have no idea of the status of acceptance, progress of diversion, and so looking at suggestions or strategies. And I think with three excellent prosecutors here, that's a really good question to are the courts being told, look, especially the post-arrest prosecutor-led, do you communicate with the court about why the arraignment is being continued or even why the case is being continued?
In Cook County, absolutely. These cases are taking place in front of the judge with the judge and the whole courtroom personnel. So if it's after arraignment, if someone has to be treated and or diagnosed and or mental health records, access to find someone's eligibility, the judge understands and knows why there's a continuance or a delay in these types of cases, and usually gives us the leeway in order to get the facts or the that we need to put someone in a program. And then sometimes it's also the delay in finding the treatment center. But certainly the judges are aware of why there's a delay in these cases. They are part of the statuses.
And Jordan, probably same question to you, especially because all of your cases are post-arrest, and you talked about null crossing cases, and you have the authority to do that. Do you communicate with the bench that we grab this case and this is what we're doing, and then do they get status updates?
And Dave, this is Rebecca. Jordan has fallen off, so I will follow up with that question to her and get back to Demetrius so he can hopefully let the attendees know the answer to that question from Jordan. Perfect.
Let's give it to Stephen and then back to Demetrius. Stephen, communication with the court, especially the prosecutor-led.
Sure. I agree with the judge. We need to, frankly, intervene as quickly as humanly possible in this process. Number one, because we want to be as close to the time as arrest as possible and address the condition while it's acute, gives us a better understanding of what happened and why. Number two is if this person's going to be in jail and untreated, there's a good chance that they'll decompensate. If they're left out in the community without treatment, there's a good chance that they're going to continue in whatever activities they're doing that we don't want them engaging in. And number three is we want to take advantage of the learning opportunity while we can. We actively communicate with everyone, but I will tell you that we are very heavily reliant on defense counsel to do their job in a lot of these cases because we can only deal with what we know about. So if we don't know that there's an underlying mental health issue, it's not identified by the police, it puts us at a huge disadvantage. The good thing for us is that our public defender's office is on board with all of this stuff. So they're regularly evaluating people and checking into these kind of issues. And they often bring this to our attention very early in the process, as well as the court's attention.
Thanks. Thank you, Demetrius, because I thought that was important. Our folks letting the court know, especially if it's gone from the police to the prosecutor, the prosecutor's leading, the courts do need to know what's happening with that case. So back to you, sir.
No worries, absolutely. And I think to Rebecca's point earlier, here are the contact information for both David and Rebecca. So if you have any follow-up questions or want any further information from the panelists or questions answered that hadn't been answered, if you can just email Rebecca or David, I'm sure they'll be happy to work with you all in terms of liaising that to the appropriate panelists and giving you some follow-up information on that. The other slide the next slide, please. Just all want to, again, bring your attention to and encourage you all to register and attend the Council of State Governments Justice Center Taking the Call. Taking the Call is a national conference exploring innovative community responder models and will bring together communities from across the U.S. to explore how jurisdictions are building comprehensive crisis systems that ensure that emergency calls receive the appropriate response. These jurisdictions are redefining who answers calls for service involving mental health or substance use crisis, homelessness, quality of life issues, and other low-level situations. We will have individual sessions for taking the call. The sessions will explore the opportunities and challenges in rethinking responses to emergency calls through strategies such as community responder models where health professionals respond to 911 calls, and police mental health collaborations. The CSG Center, along with the Bureau of Justice Assistance, the U.S. Department of Justice, and the University of Cincinnati, will be presenting and it will be a 2-day virtual conference for interested teens and individuals on October 20th to the 21st at the time listed below. We encourage you all to register for this event either as individuals or as a team of people who are working together to implement a community responder program. Again, the event is free and it is open to the public and will be held on October 21st through the 20th through the 21st, 11:30 a.m. through 5:30 p.m. Eastern Standard Time. You can register through the CSG Justice Center events page or by clicking the link that we're going to drop into the chat. The next slide. 2 minutes over if you can. All right, so thanks everyone. If you haven't done so already, we really encourage you to join the CSG Justice Center newsletter listserv. Not only is it a great way to learn about our funding opportunities such as the Justice Mental Health and Collaboration Program grant, but you will also receive information on upcoming trainings and resources from other agencies and our other partners. I also like to remind everyone that this webinar has been recorded and we will be posting this webinar along with the slide deck on our CSG Justice Center website events page. And again, thank you for joining today's webinar. Thanks for all of our speakers and panelists, and thanks for the attendees with your great questions. And please enjoy the rest of your day. Thanks, everyone.
Thank you.